Everyone. Good afternoon. Good afternoon, everyone. I hope you guys are doing great. I have a great topic for you guys, so I will wait for people to join me. But let me introduce myself for those who do not know me. My name is Ifeoma Odolami. I'm an attorney. I'm an immigration attorney. I'm also an immigrant, and my law firm is in New Jersey. But because immigration is federal law, we can serve clients in all 50 states of the United States. So thank you guys for joining me. My firm does a lot of family-based and humanitarian-based immigration. And I always say this, that knowledge is power. So today I have a topic that will be really helpful for somebody. And if you know somebody that this topic will be helpful to, please be sure to share with them. And of course, let me know, say hello, and let me know where you're joining me from. And thank you guys for joining me. And remember to click the notification bell so that you are informed whenever I have a live. So, as I said before, my name is Ifeoma Odolami. I'm an immigration attorney from the Odolami Law Firm. You can reach us for a consultation at 973-993-1900. Hi, Flight Stews from Florida. Hi, oh wow, Chicago, Florida, Winston-Salem. Thank you guys. This is so exciting to have everyone from all these different places. So, the topic is common mistakes that people make in the immigration process. And it's not an exciting topic, but it's something that you need to know. So I'm going to be sharing my screen because I really want to explain what's going on. Now, for those on Instagram, I'm so sorry that I don't know how to share the screen on Instagram. But when I will try to explain it so you can follow. And when you get a chance, you can go to YouTube and watch the presentation, okay? So I'm going to start off by sharing my screen. Let's see, share my screen. Let's see, visa bullet. Okay, this is what I'm sharing. Okay, I don't know if you can see my screen, but today we're going to talk about how dates can delay the filing of a case or can actually even get it denied. So I'm going to answer questions after my presentation. And so I want to show you guys this. This is this is a visa bulletin, and it changes every month. So I'm doing this for November 2023. If you want to get to this side, just simply type visa bulletin and maybe type the month that you are looking for. It will put you here. Now, this visa bulletin basically discusses it discusses how many visas are available in certain categories, and it discusses when those visas are available so that you know to prepare to put your petition or continue your petition. So I'm going to just discuss the preference groups, right? There are actually two, there's a final action date, and then there's the final action date, and then the dates for filing. But for the purpose of this, I'm just going to use a final action date just so I can explain what I want you guys to explain. And trust me, this is really important information. So there are four main categories here. These are family-sponsored preferences, and you can distinguish them from immediate relatives. Immediate relatives, they have a visa available all the time. And immediate relatives are a spouse of a U.S. citizen, a child of a U.S. citizen who's under the age of 21, and a parent of a U.S. citizen, and the U.S. citizen child is 21 and over. So those are immediate relatives. They always have a visa available, and that means that you don't have to wait until your priority date is current. Now, your priority date is the date that USCIS received your petition. And when you receive the receipt, it will tell you what your priority date is. With that priority date, you want to be able to check the date when you need to, your case is, when you need to file additional documents or when your case is getting closer. Now, immediate relatives don't have to worry about that, but the preference group, and I'm going to mention them now, you need to be aware of the visa bulletin. It's really important. So under F1, F1 is unmarried sons and daughters of US citizens. And another thing I want to tell you is immigration makes a difference between sons and daughters, which are people over the age of 21, right? And child, So children are under 21, sons and daughters are over 21. So under F1 category, and we distinguish this, not F1 for students, F1 for a preference group. F1 is unmarried sons and daughters of US citizens, right? Follow me, because I have a purpose for this and it's really important. And then F2A is spouses and children of permanent residents. So it's spouses and children under the age of 21 of permanent residents, right? F2B is unmarried sons and daughters of permanent residents. And remember what I said about sons and daughters. Sons and daughters mean that they're over the age of 21. Now, remember, they are unmarried. Every time you see unmarried, take a note of that, okay? Because being married changes the whole equation. Then F3 is married sons and daughters of US citizens. And F4 is brothers and sisters of adult US citizens. And these are the groups here. And you can tell that F4, they're still working on cases from 2007 for all countries except China, India, Mexico, Philippines. They have their own categories because there's a lot of immigration coming from that area in the preference group, right? So these are the F1, F2A, F2B, F3, and F4. These are the categories. And so the good thing about the preference category is that when you file for somebody in a preference category, your children under the age of 21 could be derivatives in that same petition, which means you don't have to file a separate I-130 for them. However, in the immediate relative category, if you're a US citizen filing for your wife who has a child under a certain age, I'm going to move this, who has a child under a certain age, then that child, you have to file a separate petition for them, right? So in the family preference, you don't have to. But if you're an immediate relative, you have to file a separate petition for your wife and for the child. And make sure that child qualifies as a stepchild, if that child is your stepchild, which means that you married the parent before the child turned 18. So let's get to what I want to talk about. So if you are a permanent resident, right? And I think I can close this now. If you're a permanent resident and you filed for your child, and say you filed for your child or under F2B, your child was an unmarried son, maybe age 25, right? So you are a permanent resident filing for your unmarried son on over 21, right? And then you become a US citizen, right? So that would mean that that child would move to F1, right? But what I want you guys to know is this. If you become a citizen and you're a green card holder, you become a citizen, you have a right to opt out. Opt out means you have a right to choose whether to remain in the F2B category if it's quicker, or move to the F1 category if it's quicker. So typically, if you are married, if you're an LPR and you become a citizen, you want to come to look at this at F2B, right? So F2B, they're working on cases from September 22nd, 2015, right? And under F1, they're working on cases January 1st, 2015. So clearly F2B is faster. So you would think that because you're a US citizen, it would be faster, right? Not necessarily. So you always want to come and look at the visa bulletin to figure out which one is moving faster so that you can either opt out and tell NVC that you want to stay in F2B because it's moving faster, or you can exercise your right to move to F1 because now you're a US citizen, and if it's moving faster, that's where you want to be. So everyone knows how delayed. I'm going to actually get out of this now because I can stop sharing and I can just continue talking. Everybody knows how delayed the immigration process has been. So even though it's F1 is January 2015 and F2B is September 2015, what, 9 months? That 9 months could actually be a year in terms of waiting. So that may make a difference to somebody. So basically what I'm saying is this, right? If you are an LPR, which is a green card holder, and you become a US citizen, go to the visa bulletin and check which one is moving faster. If the F2B is faster, send a message to National Visa Center saying you want to opt out and stay on the F2B track, and you will be allowed to do that. Okay? So the second thing I want to talk to you guys about is how being in the wrong category could get your case dismissed. And I'll give you an example. Now, when I showed you the preference list, if you notice, it said F2A is filing for spouses and children under the age of 21, and they have to be unmarried, right? F2B is filing an LPR, which is a green card holder, filing for children who are over the age of 21 and are also unmarried. So this is really important. There's nowhere in this category for an LPR, a green card holder, to file for a child who is married. There is no category for that. So if you file for your child and your child is unmarried at the time you file for the child, and the child goes and gets married, that application is automatically terminated. I want to say this again. If you file as an LPR for your child, as an F2B, typically because it's over 21, not a lot of under 21s getting married. So typically it's F2B, which is for unmarried sons and daughters. And that child gets married, that case is automatically terminated. And this is a really terrible thing because a lot of times you've been waiting for a long time. Because I had a consultation with somebody who had been waiting for really, it might have been maybe 8-9 years. And then the priority date was current. They got a letter from NVC saying it's time to move to the next step. And then we found out that, they let me know that the child had gotten married. When they came to me for consultation, they told me the child was now married. And I'm like, you don't have a petition anymore. It's terminated. So that's it. So you want to be aware of this. Another thing you want to be aware of is if, like, I had a client under the F1 where the US citizen parent filed for her living in another country and she was unmarried. F1 is a filing for unmarried sons and daughters of US citizens. And right now they're working on cases from that way. Their priority date is January 1st, 2015, right? So for her, her priority date came and, it was time to continue processing her case. She processed her case. She was called for the interview. She went for the interview. And just before she left her country, she got married. That is a problem because now she's in the wrong category, because if she's married, she goes to F3, which is married sons and daughters of US citizen. So now, of course, when she came to the United States, USCIS, didn't know about it until she decided to naturalize. And upon filing for naturalization, she indicated that she was married, and of course they checked the date that she got married, and it was the date before she came into the United States. And of course, that was a problem. Her naturalization was denied. And the thing is this: if she had come into the United States without getting married, come in on one day, turned around, that is, come in and was inspected, admitted, as a green card holder, turned around and left and went back to her country and got married, that would not have been a problem. But you can't change your status before you come into the country. So these are the three topics I wanted to discuss, because people are not aware that a change in their marital status could actually delay their case or terminate their case. So if you know somebody who needs this information, please give it to them. All right. So Black Greatness says, my mom is 59. She had her green card almost 5 years. I want her to go and get her citizenship, but there's a problem. She can't read, and I've heard about certain exemption if you are of a certain age. Well, Black Greatness, there is a certain exemption if you're 65, right? And you can show that you have a medical exemption, right? You can get an exemption. Now, if your mother cannot read and write, can she speak the English language? Because there's also an exemption for people to take the test in their language, depending on their age and how long they've had their green card. So that might help your mother. Now, if your mother has a cognitive medical problem, right, that makes it difficult for her to understand, you could also get a medical waiver, right? So you might want to look into that, okay? Let's see. Let me see if I have any other questions. Let's see the other questions. Okay, your mom can speak English. That's the language she speaks. Okay, so the exemption for elder applicants are really that they're age 65 and they've had their permanent residence card for at least 20 years. There's an exemption for that, but she's not 65 yet, so that's not going to be helpful. And for that age, I think they give them less questions. I just want to be sure about it. They give them less questions. It's not that they're totally exempted. I think they get less questions. They can study for, I think, a certain amount of questions. So there are 3 exemptions. You should look it up. I think there's one for 15. There's a 1555 exemption, which is you're 55 years old. You've had your green card for 15 years. And then there's the sorry, I get this confused. I think it's the 55 years old, you've had your green card for 15 years. Then you're 50 years old, you've had your green card for 20 years. And then there's a certain exception for elder applicants over the age of 65, okay? Take a look at it. I haven't looked at it in a while, but yeah, that's how it works. So Laura says, hello, the fact that we got married and the fact that we get married and got divorced during the paper process can cause the termination of the green card. On this case, what do you do to continue the process? Hello, the fact that we get married and divorced during the... Okay, I see what you're saying. You're saying that you got married and then got divorced while your spouse had filed a petition for you, but you hadn't gotten the green card yet. So Laura, this is the thing. If you were in a relationship and maybe the divorce or you suffered abuse during the relationship, you may qualify to file for VAWA. VAWA does not require you to be to be, to be married, or, doesn't, sorry, VAWA requires you to be married, but VAWA does not require that you continue with the process if you're being abused in that relationship. So if you're in an abusive relationship and you're still waiting to get your green card, you can file VAWA. However, if you're not in an abusive relationship, not at all, and everything is going okay, and it's just not working out, well, remember, it's the person's petition, and that green card application will terminate if you guys divorce based on just, we don't want to be together anymore. But if it's based on abuse or extreme cruelty, then VAWA would be your option. Okay. All right. Let me see the other questions here. Let's see Instagram. See Instagram. I try to answer the questions, but it just goes by, the screen goes by so fast, and sometimes it's so tiny. So can someone apply for one parent I-130 and then will sponsor the other parent, or you have to apply for separate I-130s? So I think what you're asking, Chalokin, is if you're applying for your parents, can you use one petition? No. So if you're applying for your parents, you file an I-130 for one parent, you file another I-130 for the other parent. In the alternative, the parent that you file for, when they get their papers, they can file for the other parent, but your parents are not derivatives of each other. All right. I'm just looking for questions. So someone says, I want to ask you, how can someone who holds a visitor's visa get a job and a work permit? That would be a really great question to answer if there was a simple answer to it. So Empire, I think your best bet is to talk to an immigration lawyer to see if because if you come in a visitor's visa, sometimes you can change your status. You can change your status, but it depends on a whole variety of factors. So since you're looking to get a job and a work permit, I'm going to suggest that you look for a lawyer that does employment immigration. Okay, they may be able to assist you and give you information that would help you make a decision as to what to do. All right, let's keep going. So Marilyn says, if a person gets their work permit and Social Security, how long does it take for them to get their first green card? So Marilyn, that's a really great question, but when you get your work permit and your Social Security card, I'm assuming that you got it through, there are different ways to get your work permit. You could have gotten it through somebody filing a petition for you. You could have gotten it through asylum. You could have gotten it through a VAWA application, a U visa, T visa, and it all depends. Each of this category, there's no fixed answer as to how long it was going to take you to get your green card. We've had clients who we filed an I-130 adjustment of status petition where their spouse filed for them, and they got their green card even before the work permit came. Typically you're supposed to get a work permit and then a green card. And sometimes in that situation, we get a work permit and then the green card comes really quickly. But there are people who get their work permit and they have to wait a long time for their green card, depending on the petition that they filed. I hope that answers your question. Okay. So Karen says, can you travel with advanced parole safely? See, Karen, that's a really great question. And this is what I say, right? First of all, if you're in immigration, if you're in deportation proceedings, you have no reason to leave this country for anything. You should not. Now, typically, if you're in deportation proceedings, you're probably not even going to get advanced parole, but sometimes there's a mix-up, or, you get your advanced parole and then you're put in deportation proceedings. So the first thing you need to know is, if you're in deportation proceedings, you should not leave the country. Now, if all things are equal, the advanced parole is supposed to give you permission to leave the country and come back, but it's not guaranteed. I want you to know this. So if, for instance, you take an advanced parole and you leave the country and you come back into the country, and during maybe there's a secondary inspection, they find something that makes you inadmissible, that's a problem for you. Or assume that you're, say, traveling to some country, and you commit a crime, and USCIS is aware of it. That could be a problem for you coming back in. So what I say with regards to advanced parole, it's a personal decision. So all my clients that use the advanced parole to travel have gone out and come back safely, but I always caution them about the fact that the advanced parole is not an automatic permission to enter, because there might be issues that make you inadmissible that may not have been present at the time you were given the advanced parole, or just USCIS becomes aware of additional information. Okay, so that's Anthony says, do you do EB for religious workers? Anthony, I do not. So Live says, please can you advise, I went for an interview and the response I get after 90 days is a notice explaining USCIS action on my case. Please advise. Live Drama, I don't understand this question. I'm going to need more information. So you might want to contact my office, 973-993-1900. See if we can assist you. So Nelline John says, my I-130 was approved, but my I-485 was denied. I filed a motion to reopen and was granted. How long do I take to get a green card? So Nelline John, this really depends. I'm going to need more information on this. Why was your I-485 denied? And you filed a motion to reopen. So that's awesome. So the case is back on. It's really going to depend on your field office. If your I-485 was reopened, which is great, it's going to depend on your field office. How long is the wait? Sometimes they want to interview you and you may have to wait for an interview, and sometimes it's slow and it's going to take a little while. So it really depends. All right. It would help if I had more information about the case, then maybe I could give you my best guess. All right. Believer Scrum says, if a U.S. spouse refuses to go for a Stokes interview, is a person automatically barred for fraud? Believer, there's no automatic bar for fraud because your U.S. citizen refuses to go for a Stokes interview. It's not automatic, but USCIS can make a finding based on whatever information they have. And when you say fraud, I'm thinking your marriage fraud, 204C, which 204C is the permanent bar. So if you don't show up for an interview, it's not an automatic bar, but USCIS is within their right to make a finding based on whatever information they have as to whether or not it's a fraudulent marriage. Okay. All right. So Guy Magwit says, my question is, if a husband applies for his wife overseas, then husband as a sponsor dies, is the case terminated? Guy Magwit, that's a great question, and not necessarily. So my question to you would be, was the I-130 approved before the husband passed away? Because there's something called humanitarian reinstatement that may apply to your case if that's the case. But look into that, because the death of a petitioner in an I-130 petition does not automatically terminate the case. It's really helpful to know whether the I-130 was approved before the husband passed away. So Rachel says, if I'm a citizen, can I petition for my husband who has a pending asylum and his son who is 11 and out of the USA at the same time? So your husband has a pending asylum and is in the United States, right, Rachel? Yes, you can petition for him. There's no limit to green card petitions. You can have a pending asylum, and you can also have a marriage application. And he has a son who's 11 and outside the United States. Yes, you can also petition for his son. You would have to do that by something called consular processing. Now, with regards to your husband, whether or not he can adjust his status depends on how he came into the United States. Did he come with a visa and overstayed the visa? Or did he come through the border? If he came through the border, he's not going to be able to adjust without filing a waiver. However, there are many exceptions, so you would need to have a proper consultation with an attorney to see if there's any exceptions for your husband with regards to adjusting his status if he came through the border. Let's see. Pretty for Day says, how can I file for my daughter? She's 12. I got a green card through VAWA. So Pretty, that's actually a strange question, because if you got your green card through VAWA, your daughter should have been a derivative. She should have been able to get her green card through your process. I mean, there's additional stuff to do. Like if she was here, you'd have to file an adjustment of status. If she was here, if she was in her country, you would have to file another, I think it's the I-821, I think, Form I-821, I think, which basically is an action on, an approved petition. So I think you should talk to an attorney and see if your daughter qualifies as a derivative to get her green card through, because you already got it through VAWA. You would not need to file a new petition. She may just need to do adjust her status or continue the process through consular processing. Okay. So Steve says, are absolute decrees for divorce accepted from customary Nigerian courts in USCIS? So Steve, I think you're saying, is that decree absolute is what you're asking for? Is it accepted for customary Nigerian court? So Steve, if you go to the travel.state.gov, it tells you exactly what is accepted. Typically, if you get married in a registry, USCIS is looking for, or you have a church wedding that was registered in Nigeria, registered in the registry, they're going to need a decree nisi and a decree absolute. Now, if you have a customary marriage, it would depend, because sometimes customary marriages don't have divorce, they don't have formal divorces. Sometimes you can get a divorce through customary court. I think that would depend on where you're from and what traditions are followed with regards to customary marriages. All right, guys. I got to run now, but I tried to answer as much questions as I could. So I will be back, and like I said, if this video is helpful to somebody you know, please be sure to share it, because it's really, really important that people do not make mistakes that either delay or cause their green card applications to be denied, especially in this day and age where immigration cases are taking forever. All right, guys, take care, and I will be back another day.